The courtroom doors swung open at 9:02 in the morning, and Judge Alina Preyas looked up from her papers expecting to see a bailiff, or maybe a late attorney. Instead, she saw a line of people that did not seem to end. Farmers in pressed shirts they clearly did not wear often, a postal worker still in uniform, a retired schoolteacher leaning on a cane, a veterinarian, a gas station owner, a woman in her 80s who had to be helped up the courthouse steps by her grandson. One by one, then two by two, then in clusters of 10, they filed into the gallery of a small county courtroom built to hold maybe 80 people, and they kept coming until the fire marshal quietly asked the bailiff whether this was even legal. 67 of them in total, each one carrying a single sheet of paper. At the front of the room, seated at the defendant's table, sat Walter Hale Jr. 79 years old, in the same brown suit he had worn to his wife's funeral 11 years earlier because it was the only suit he owned. His hands, thick and cracked from 60 years of pulling wire and setting fence posts, were folded on the table in front of him like a man praying at church, except his eyes were fixed on the man seated across the aisle. His younger brother, Daniel Hale, 68 years old in a suit that had clearly been bought for this exact occasion, did not look at Walter at all. He was looking at his lawyer, and his lawyer was looking at the growing crowd with an expression that had shifted, in the space of about 90 seconds, from mild confidence to something closer to panic. Because Daniel Hale had come to this courtroom to prove, with the help of one paid psychiatric evaluation and a great deal of persuasive language, that his older brother had lost his mind, that Walter was no longer competent to manage his own affairs, no longer fit to hold the deed to the 400-acre farm their father had built from nothing, and that the court should appoint Daniel, his loving, concerned younger brother, as legal guardian with full authority to sell the land Walter had spent his entire life protecting. 67 neighbors had shown up to tell the court, in writing and in person, that Daniel was wrong. And what none of them knew yet, not the judge, not Daniel, not even most of the people in that gallery, was that the stack of signed statements in their hands was about to reveal something far more damning than a disagreement about an old man's memory. It was about to expose exactly what Daniel Hale had been doing for the better part of a year, and why he was so desperate to get his hands on that farm before anyone found out. To understand how 67 people ended up standing in a courtroom for a man most of them weren't even related to, you have to go back 4 months, to the spring morning when Walter Hale found the first surveyor's stake driven into his own back field. Walter Hale had farmed the same 400 acres outside a small town for 57 years. His father, Walter Hale Sr., had cleared half of it by hand after the war, and Walter had spent his boyhood picking rocks out of soil that didn't want to give up easily. When his father died, the land went to Walter, the eldest, with the understanding, never written down, just understood, the way things were understood back then, that he would look after his mother and his younger brother until they were settled. Walter had done exactly that. He paid for his mother's care until she passed. He co-signed loans for Daniel's first 2 business ventures, both of which failed. He never once brought it up at family dinners, never held it over anyone's head. He just kept farming. Daniel, meanwhile, had left for the city at 22 and spent the next 4 decades chasing one opportunity after another: a car dealership, a strip mall development, a chain of tanning salons, none of which ever quite worked out the way he promised investors it would. By the time he turned 65, Daniel was living in a rented condo, 3 divorces deep, and quietly, desperately in debt to people who did not send friendly reminder letters. Walter didn't know any of that in detail. He knew his brother called every few months, always cheerful, always asking how the farm was doing, and Walter always assumed that was just Daniel being Daniel, a little distant, a little slick, but family. Then on a Tuesday morning in March, Walter walked his back field the way he did every morning of his life, coffee in hand, and found an orange survey stake driven into the ground near the tree line. Then another. Then 6 more, forming a neat grid across nearly 60 acres of his own pasture land. He called the surveying company listed on the little flag attached to the stake. The young man on the phone was polite and confused, and after checking his paperwork, told Walter that the job had been commissioned by a Daniel Hale, who was listed as the property's authorized representative, in preparation for a potential sale to a developer interested in building a distribution warehouse. Walter stood in his own field for a long moment, holding a phone, listening to a stranger explain that his brother was trying to sell land that was not his brother's to sell. That evening, Walter called Daniel directly. Daniel's tone on the phone was smooth, almost rehearsed, the way it always was when he was managing a situation rather than having a conversation. He told Walter not to worry about it, that it was just exploring options, that nothing had been decided, that he was only trying to help Walter see what the land could be worth if he ever wanted to retire and enjoy his remaining years, instead of working himself into the ground. Walter told him plainly that he had no intention of selling, that the surveyors needed to be off his property by the end of the week, and that he expected an apology. He got neither. 3 weeks later, a letter arrived from a law firm 2 counties over. It was not an apology, it was a petition. The letter informed Walter Hale that his brother, Daniel Hale, had filed a petition in county court seeking guardianship and conservatorship over Walter's person and estate, on the grounds that Walter was exhibiting signs of significant cognitive decline that rendered him incapable of managing his own financial and property affairs. Attached to the letter was a preliminary psychiatric evaluation from a doctor Walter had never met based on an assessment that turned out to be a 20-minute phone call Daniel had arranged 8 months earlier, during which he told Walter it was simply a routine wellness check the county does for older farmers for insurance purposes. Walter remembered the call. He remembered answering a series of odd questions about dates and names and counting backward from 100 by sevens, questions he'd found strange but harmless at the time, since his brother had assured him it was standard procedure. It was not standard procedure. It was evidence. The report described Walter as showing moderate impairment in short-term recall and executive function, consistent with early-stage cognitive decline, and recommended that a trusted family member assume fiduciary responsibility for the patient's affairs to prevent financial exploitation or self-harm through mismanagement of assets. Walter read the letter 3 times at his kitchen table before he fully understood what it meant. His brother was not just trying to sell a piece of the farm. He was trying to have Walter legally declared incompetent, take control of the entire estate, and sell whatever he wanted, however he wanted, with Walter having no say in the matter at all. Walter did what a man of his generation and temperament tends to do when the ground shifts beneath him. He didn't call a dozen lawyers. He didn't post about it online. He drove into town, sat down at the counter of the diner he'd eaten breakfast at for 30 years, and told the woman who ran it, a widow named Ruth Callahan, exactly what had happened. Ruth put down her coffee pot and said, "Walter Hale, that is the most ridiculous thing I've heard in my life, and I need you to let me tell some people about it. Word does not travel through small towns the way it travels through a phone line. It travels through porches, through church pews, through the line at the feed store, through the booth at the diner where 4 men who have known each other 60 years drink coffee every single morning at exactly 7. By the end of that week, there was not a person within 15 miles who had not heard some version of the story. That Daniel Hale, who hadn't set foot on that farm in 3 years, who most people barely remembered, was trying to have his own brother declared incompetent so he could sell the land out from under him. And nearly every single one of them had an opinion about Walter Hale's mental state, because nearly every single one of them had done business with him in the last 12 months. If Daniel's lawyers had done their homework properly, they might have understood what kind of mistake they were making, because Walter Hale was not some isolated old man rattling around an empty farmhouse, easy to paint as forgetful and vulnerable. Walter was, without question, one of the most active and well-known men in the entire county. He still ran his own equipment. He still balanced his own books by hand, in a ledger he'd kept since 1987, and every entry in that ledger was correct down to the penny, because Walter Hale did not believe in owing anyone anything he couldn't account for. He served on the volunteer fire department's equipment committee. He'd negotiated, just 4 months earlier, a new grain contract with a co-op 2 counties over that had saved him nearly $9,000 over the previous year's terms. A negotiation the co-op's own manager would later describe as sharper than most men half his age. He mentored 2 younger farmers who'd taken over family land after their own fathers passed, walking their fields with them, explaining soil rotation and equipment maintenance, and how to read a weather pattern before it read you. He sat on the board of the local Grange Hall. He had, 3 weeks before the guardianship petition was filed, personally caught an error in his own property tax assessment that the county itself had missed, and gotten it corrected. None of that sounded like a man in moderate cognitive decline. When the petition became public record, and the hearing date was set, a retired attorney named Harold Voss, who had known Walter since they were boys and now spent his days fishing, and occasionally advising his neighbors for free, sat down with Walter and explained exactly what the process would look like. The court would hold a competency hearing. Daniel's side would present the psychiatric evaluation and argue for guardianship. Walter's side needed to demonstrate, clearly and convincingly, that Walter was fully capable of managing his own affairs. "The problem," Harold said, "is that a report from a licensed psychiatrist carries a lot of weight in that room, even a flimsy one. We need more than your word against a paper. We need people who have watched you make decisions, real, current, everyday decisions over the last year, people a judge will believe." Walter said he supposed he could ask a few of the fellows from the co-op. Harold laughed, not unkindly. "Walter, I don't think you understand how many people are already asking me how they can help. It started with the 4 men at the diner counter, then Ruth Callahan herself. Then the co-op manager who'd negotiated that grain contract, who wrote out in his own hand a full account of the meeting and how sharp and specific Walter's counteroffers had been. Then the 2 young farmers Walter mentored, who each wrote pages about the practical, detailed, up-to-date guidance he still gave them weekly. Then the Grange Hall board members. Then the fire department committee. Then the county assessor's office clerk, who confirmed in writing that yes, Mr. Hale had indeed caught and corrected an error in his own tax record just weeks prior, an error that had gone unnoticed by 2 separate county reviewers. Harold Voss began organizing the statements formally, sworn, notarized, dated, each one describing a specific interaction, a specific decision, a specific demonstration of clear thinking, because a judge would need specifics, not just Walter's a good man, which any character witness could say about anyone. Word kept spreading. A woman Walter had never even met personally, whose late husband had bought a used tractor from him 18 months earlier, came forward, because she remembered how carefully Walter had walked her husband through every mechanical detail of the machine, how he'd insisted on a fair price, even when her husband had offered more. A young mother whose son had gotten his truck stuck in a ditch on Walter's back road. One icy night said Walter had come out at 11 at night with his own tractor to pull the boy free, refused any payment, and then spent 20 minutes explaining exactly what winter tires the boy needed and why in more technical detail than the boy's own father had ever bothered with. By the end of the 2nd week, Harold had 31 statements. By the end of the 3rd week, he had 49. People Walter barely remembered meeting were showing up at Harold's little office above the hardware store, wanting to add their name to the list, wanting to describe some small interaction that proved, in their eyes, that this was a man fully in command of his own mind. It reached 67 statements 4 days before the hearing, and Harold Voss, staring at the stack of paper on his desk, told Walter something that stuck with him. "In 40 years of practicing law in this county, I have never once seen anything like this. This isn't a character reference anymore, Walter. This is a community standing in a doorway." Meanwhile, on the other side of the case, something else was quietly falling apart. Daniel Hale believed, right up until the morning of the hearing, that this would be simple. He had a psychiatric report. He had a lawyer. He had in his mind an old man who lived alone on a farm too big for him, an old man who would seem frail and confused in front of a judge. An old man whose objections would sound exactly like what a declining mind sounds like when it insists it isn't declining. What Daniel had significantly underestimated was the sheer, specific, overwhelming volume of contrary evidence, a small, tight-knit community could produce when one of its own was threatened. And what he had failed entirely to anticipate was that pulling on this particular thread would eventually unravel something Daniel very much needed to stay hidden. Because Harold Voss, in preparing for the hearing, had done something Daniel's lawyer never expected. He had subpoenaed the full financial records behind the surveying request and the developer contact, the same distribution warehouse company whose interest had started this entire chain of events. What those records showed was that Daniel had not simply floated an idea about selling family land for retirement money. He intended to share. Daniel had already signed a preliminary letter of intent with the developer 6 weeks before he ever filed the guardianship petition. A letter promising a sale price, a closing timeline, and buried in an addendum a separate finder's and consulting fee payable directly and exclusively to Daniel Hale personal. Not tied to the estate, not disclosed to Walter, and structured in a way that would only trigger if Daniel personally controlled the sale as legal guardian. In plain terms, Daniel wasn't trying to help his brother retire comfortably. He was trying to engineer a legal declaration of incompetence, specifically because it was the only path by which he could personally pocket a payment that had nothing to do with Walter's well-being at all, a payment large enough as it would turn out to cover debts Daniel had been drowning in for years. Harold didn't plan to lead with this. He planned to let the 67 statements do the talking first, let the judge see, in overwhelming and specific detail, exactly who Walter Hale was. The financial records were the second blow, the one that would explain why any of this had happened at all. The hearing was set for a Thursday morning. Nobody on Daniel's side had any idea what was walking through those courthouse doors. Judge Eleanor Preyas had presided over dozens of guardianship petitions in her career, and she had never seen a gallery like the one that filled her courtroom that Thursday morning. When the bailiff informed her that the fire code capacity had technically been exceeded, and additional attendees were now standing in the hallway outside, she paused the proceedings for 10 minutes simply to have the situation sorted out. When the hearing formally began, Daniel's attorney opened by presenting the psychiatric evaluation, walking the court through its findings on cognitive decline, framing Daniel as a devoted, worried brother reluctantly forced to seek legal protection for a man who could no longer protect himself. Harold Voss's response was simple. He did not attack the report directly, not yet. He simply stood and said, "Your Honor, I have 67 sworn, notarized statements from members of this community, each describing specific, recent, documented interactions with Walter Hale. Interactions involving contract negotiation, mechanical instruction, financial correction, and complex decision-making, occurring within the past 14 months. I would like to begin reading a representative sample into the record." What followed took nearly 90 minutes. The co-op manager's account of the grain contract negotiation, the county clerk's account of the tax correction, the young farmer's detailed descriptions of ongoing mentorship involving real-time agricultural decisions, the account of the 11 o'clock rescue on the icy road, complete with the specific tire recommendations Walter had given, which the boy's mother had actually gone out and purchased the following week, exactly as advised. By the time Harold reached the 40th statement, Judge Preyas had stopped him twice, not to object, but to ask clarifying questions of her own, questions that made clear she was no longer simply listening to a defense. She was building a picture, statement by statement, of a man whose mind was demonstrably, functionally, thoroughly intact. Daniel's attorney tried to object to the cumulative nature of the evidence, arguing repetition didn't strengthen the case. Judge Preyas overruled him, noting dryly that the sheer number and specificity of consistent, independent, unrelated accounts was, in fact, precisely the kind of evidence a competency hearing existed to weigh. Then Harold played his second card. He introduced, into evidence, the preliminary letter of intent between Daniel Hale and the distribution developer, dated 6 weeks before the petition, along with the private finder's fee addendum tied exclusively to Daniel's personal guardianship. The courtroom, which had been tense but composed for nearly 2 hours, went completely silent. Daniel's own attorney turned to look at his client for the first time since the hearing began, and the expression on his face was not one of a lawyer confident in his case. Judge Preyes asked Daniel's attorney directly whether his client had disclosed this financial arrangement to the court, to Walter Hale, or to the psychiatrist who had conducted the original evaluation. The attorney asked for a recess to confer with his client. The recess lasted 40 minutes. When the hearing resumed, Daniel's attorney informed the court that his client wished to make a personal statement. Daniel stood, for the first time that morning, actually looking at his brother, and what came out was not quite an apology and not quite a confession, but something uncomfortably close to both. He said he had been in significant financial difficulty. He said he had believed, genuinely, that selling a portion of the farm would benefit both of them in the long run. He said he had not intended to hurt his brother, only to move things forward. In a way, he felt Walter was too stubborn and too sentimental to do himself. He did not directly address the undisclosed finder's fee. Judge Preyes noticed the omission immediately and asked about it herself. Daniel's answer was quiet and vague and did nothing to help him. Judge Preyes did not need much more time to reach a decision. She noted, for the record, that the psychiatric evaluation appeared to have been obtained under circumstances that were, at minimum, misleading to the patient, and possibly conducted in a manner inconsistent with proper informed consent. She noted that the 67 statements presented represented an extraordinarily consistent, specific, and current picture of full cognitive and functional competence, one of the strongest evidentiary records she had personally encountered in a guardianship proceeding. And she noted, with unmistakable weight in her voice, that the undisclosed financial arrangement raised serious concerns about the underlying motive for the petition itself. She dismissed the guardianship petition in full. She further stated, on the record, that she was referring the matter to the county for review of possible elder financial exploitation, and that the psychiatric evaluation and the circumstances under which it was obtained would be reported to the appropriate licensing board. Walter Hale did not smile. He did not celebrate. He simply exhaled, the way a man exhales after finally setting down something heavy he'd been carrying without complaint for weeks. Behind him, 67 neighbors rose to their feet. Outside the courthouse, Walter Hale was met by a crowd that made the local paper's photographer take 3 separate pictures because he couldn't fit everyone into a single frame. People shook his hand. Ruth Callahan hugged him and told him breakfast was on the house for a month, an offer Walter tried and failed to talk her out of. The co-op manager clapped him on the shoulder and said something about how he'd never doubted him for a second, which wasn't entirely true, but nobody minded the exaggeration on a day like that. Daniel left through a side entrance, alone, his attorney a few steps ahead of him, already checking his phone for messages that had nothing to do with Walter Hale's farm. The county did open a formal review into the circumstances of the psychiatric evaluation, and the developer's letter of intent quietly evaporated once it became clear the man who'd signed it never had the legal authority to promise anything. The distribution warehouse project moved on to another parcel of land 40 miles away, on property whose owner, as it happened, was actually looking to sell. Walter kept farming his 400 acres. He kept his ledger by hand, exactly the way he always had. He still mentored the 2 young farmers down the road, still sat on the Grange Hall board, still caught the occasional error in his own paperwork before anyone else did. He and Daniel did not speak again for the better part of a year. When they finally did, it was a short, careful phone call, not quite a reconciliation, more of a quiet acknowledgement that the damage had been real and the trust had not simply reappeared because a judge had ruled. Walter, being who he was, did not slam the door shut entirely. He told his brother that the road back, if Daniel wanted it, was going to be long, and it was going to start with honesty, not persuasion. What stayed with Walter longer than the anger, longer even than the hearing itself, was the memory of that courtroom door opening again and again, that Thursday morning of face after face he recognized from a lifetime of small, ordinary interactions. A grain contract here, a stuck truck there, a tax form corrected on a Tuesday afternoon, each one deciding, on their own, without being asked twice, that this was a fight worth showing up for. 67 people had walked into that courtroom carrying a single piece of paper each. But what they were really carrying, Walter understood later, was proof of something far simpler and far harder to fake than any medical evaluation could ever measure. A lifetime of showing up for other people finally being returned in kind all at once on the one morning he needed it most.